So the deceased person didn't have any living descendants. What's the next step in the analysis? Kind of the same as we did over with a married person. We then say, okay, well, are parents living? If the parents are living, then 100% of the estate goes to the parents. Now, when I say parents, same sort of thing. We are not talking about a step parent. Perhaps, you were raised by someone, your stepdad, and he never adopted you, and you're not his biological. He married your mom, your biological mom, and you considered him to be your father for all intents and purposes. But legally, he's not. And so if you are a single person and you have no kids and you die, your estate is going to go half to your mom, half to your biological dad, even if biological dad had nothing or very little to do with you. Your stepdad is not going to inherit from you. So you were raised by mom and stepdad, and now mom's deceased. Stepdad doesn't get any of your estate. 100% goes to your biological dad. If that's not the result that you want, you will have a will to make sure that that's not what happens when you die. All right, next step. Let's say your parents aren't living, neither one of them. Then do your parents have any living descendants? Again, that's your siblings, or if one of your siblings is deceased, nieces and nephews from that deceased sibling. In that event, 100% of the estate goes to your parents' descendants, your siblings, your nieces and nephews, and then they divide it up. Next step. Okay, well, no, your parents don't have any living descendants. You have no siblings, or if you had siblings, they're deceased and they didn't leave any kids or grandkids of their own. Okay, so then the state is going to look up to say, do you have any grandparents living? And if you do, then your estate goes to your grandparents. If you don't have any living grandparents, then if there are any descendants of your grandparents, here what you're thinking about are cousins. If there are descendants of your grandparents, then your cousins, all of them split your estate. Okay. All right. There's no cousins. There's just no living family relations you have. Then the next question the state is going to ask is, well, do you have stepchildren from a deceased spouse? If the answer is yes, then the next question is, did that late spouse leave pretty much their entire estate to you? And if they did, then on your death, then your stepchildren actually get your estate. In the event that we've answered no, that either you don't have any stepchildren from a deceased spouse, or that late spouse didn't leave their entire estate to you, that your estate comes from elsewhere, then on your death, here is where your assets, your estate, escheats or goes to the state of Washington. So here at this level here, this RCW 11.04.095 was put into place by the legislature to give some sort of a safety valve so that if there was an opportunity for stepchildren to inherit from you, they would. And if these are answered no, that you don't have stepkids or you didn't inherit from your late spouse, the estate basically goes to the state of Washington. Generally speaking, nobody wants their estate to go to the state of Washington, but you can see that is what will happen in the situation where a single person doesn't either have any living family members or stepkids. That was the state gets all your assets.